I want to start by acknowledging that we're holding this meeting on the territory of the Wasanich people, and we daily benefit from their wisdom, their culture, their traditions, their way of life, their stewardship. And I just want to acknowledge with a great deal of respect and humility being able to hold a meeting on these lands. Before we get into the heart of the meeting and get going with our panel discussion, I'd like to say a few words about how this meeting came to be and the work that we're going to, the good work we're going to do this afternoon. And it's very much been a team effort involving in having this concept and getting it going between myself and John Juricic, who many of you know, Sydney Breakfast Club Business Incubator. The goal of the meeting and what brought me to want to work on this, and I'm Rob Botterell, I'm the MLA for Saanich North and the Islands, was that I've been fielding a lot of questions about the Cowichan decision, Gitxaala, DRIPA, impacts to the business community, and what reconciliation means to us all. And I thought it'd be helpful to bring together distinguished experts to share their knowledge with us and to equip everyone with tools, information, and reasoned analysis to answer the questions on your mind and questions that I'm receiving almost daily from constituents. And so for me, that was the impetus to set this meeting up and to get away from the cut and thrust of question period and the instant problem solving on social media and the tone of some of the debate. And so this is what I hope will be a respectful discussion and an opportunity to really learn more about these issues from some very distinguished panelists. You don't see my bio there. If you want to read about what I did for 25 years working in Indigenous law, check out botterell.ca. But the whole purpose of this is to be non-partisan and to really draw on some depth of expertise. You've got a copy of the bios of the panelists. I don't propose to go into a whole lot of detail for that reason, but we have Andrew Petter, who's a former Attorney General for British Columbia, former president of SFU, served in numerous portfolios from 1991 to 2001, including Aboriginal affairs, and brings a national expertise on constitutional law and other areas. We have Geoff Plant, who's counsel in the Vancouver law firm Gull Leg Grant Swack LLP.
They pay me, so
and was on the government team for the Delgamuukw trial. Has appeared as counsel in many court cases, including most recently Cowichan Tribes case. And from 2001 to 2005, he was Attorney General for British Columbia, Minister responsible for treaty negotiations, and heavily involved in some of the innovative work that happened at that time, including the negotiation of the new relationship and the first ever political accord between the government of BC and the province's 3 Aboriginal political organizations. So a wealth of experience. And then we're lucky enough to have Adam Olsen with us, who is now the Director of Intergovernmental Relations for Sartlip First Nation, where his work sits at the intersection of Indigenous rights, land stewardship, and the ongoing implementation of DRIPA. And many of us will know him from his former work as a member of the legislature from 2017 to 2024, which was part or is part of a 16-year career in elected public service. He writes and speaks in a whole bunch of venues and adds a whole lot of wisdom and thought to the future of issues involving Indigenous people in this province. So this is your panel. I'd love you to give them a big hand and we'll get underway. The structure of the afternoon is, I'll just describe it in words, is to try and make this as engaging as we can while recognizing that there's some folks in the audience who have a huge depth of knowledge and experience, and others that this is really new, or it's something where you'd like a refresher. So in the first part of the afternoon, we're going to do a bit of a history and a bit of a primer, and I hope you'll bear with us. We'll try and not make it sound like a lecture. Then we'll talk about case law leading up to the period before Cowichan and Gitxaala, and give you a bit of an overview of that. And then we'll get right into the Cowichan decision and what it means and the path forward on that. Then we'll deal with the Gitxaala decision, DRIPA, UNDRIP, and how that flows. And then suddenly it'll be 4 o'clock and we will have solved all the problems of the world. That is my commitment to you. We will solve all the problems of the world in 2 hours flat.
Still a rookie politician.
Yeah. I'm still learning the ropes, and I do have a one-way ticket ready to use. I'd like to begin by asking Adam if you could give us a bit of a recap of what is the history of the BC land question from a First Nations perspective, and what does reconciliation mean and look like for First Nations in this province? And the reason I want to ask that question is roughly 3 weeks ago at Mary Winspear, Adam and George Abbott gave this great 2-hour presentation and discussion of what the history is that underlies what we're dealing with right now. And I think that's a good place to start. I also think that, and just want to mention, we're going to be really focused on the land question this afternoon, where there's so many other areas we could deal with, fisheries rights, all sorts of others, but we're going to focus on the land question this afternoon. So over to you, Adam.
Yeah, thank you. And it's Gitxaala. Good to see you all. Tsahanup Tinitsne. Tsahanup is the name that my family gave me, and it's an honor to be here with you. And born and raised right here on the Saanich Peninsula. I guess it's characterizing the history of the land question. So going back to 1763, right? The Crown said you have to. Indigenous people have rights to the lands that they inhabit and that they use, and it's incumbent upon the British Crown and all of their loyal subjects and their representatives to extinguish or to come to an agreement to purchase lands that were to be settled. And if you look across the country, you see the Dominion of Canada was largely settled that way. And you get to British Columbia and you see almost or entirely none of that. And it was a special approach that was taken here in British Columbia by a group of founding figures, founding people of this province that decided that we were uniquely this jurisdiction was unique, and that Indigenous title did not need to be extinguished or purchased or settled in advance of settlement. And the James Douglas started a process to recognize Indigenous title that was basically stopped when Joseph Trutch and many others, actually many others, but Trutch was a key figure in really entrenching a policy of denying Indigenous title existed, stating, in fact, very clearly that Indigenous title did not exist, and building a policy in British Columbia around that statement and around that legal theory, really. And that stayed the heart, the core of our Crown Indigenous relationship was that there was no need to settle the Indian land question. In fact, it had already been settled by Joseph Trutch when they determined unilaterally that it didn't exist. Until the mid-20th century, when Indigenous people finally were able to start to use the court systems to ask questions. And Indigenous people right across the country started, or across the province, I should say, started asking questions, and the courts started to provide answers, starting with Calder, and we'll get through and talk about the legal history. But essentially, what we uncovered through uncovering the first 100 pages of George's book Unseated, George Abbott's book Unseated, was that time from about 1861, I think it was, right through to when British Columbia joined Confederation, and the policy that became entrenched in this province and that guided decisions that were made around Indigenous and Crown land. And really, I think the reckoning that we're facing right now in this province was set at that time. It was set in motion, and now we have inherited that, and now we have to find a way through it. And our courts have been very relentless, as we'll talk about as we go through, and just making it very, very clear that this is both inevitable that we find ourselves in this position today, and that it's very inescapable, that no matter what we do to continue to try to run away from it, it will catch up to us, and we're feeling that today.
When you look at that history, what does reconciliation mean to you? What does it mean to Indigenous people?
Well, I think it's ensuring that there's some justice. There is a dramatic socioeconomic gap just on, the ditch that ran down Stellies that we used to race our sticks down is a symbol for me, and it's long been a symbol for me, because on this side, life expectancy is one thing, and on that side, life expectancy is another thing. And I was at Reynolds yesterday, and I made the point, because a guy I grew up with as a teacher at Mount Duggan, he was sitting there, and I said, if you were just to take Canadian statistics alone, Sean is going to live 10 years longer than me, right? And that's the outcome of the policy that became entrenched in British Columbia. It's just one statistic, but as you go through the statistics, you start to see a very bleak picture of what those deliberate policy decisions that have been made and sustained over decades has resulted in. And so for me, reconciliation is about, it's about justice. It's about ensuring that our policy decisions aren't creating these inequitable and unjust outcomes, especially when we have all of the power and all of the imagination and all of everything that we need in order to send them in a different direction.
Great. No, and I think we want to start out with this because that really is at the core of why we're here today. And as I look at it, and I really encourage everybody, if you haven't, to pick up a copy of George Abbott's book Unseated, because it provides an incredible, detailed picture of just exactly what Adam's mentioned.
Can I read you a quote?
Yeah.
So this is a quote from Lord Dufferin, 1876. And it's an important quote because it's noting that there's a recognition that that British Columbia was on the wrong track by the Dominion of Canada, by the federal government. Lord Dufferin is in the government house here in BC, and all of the politicians would have been around. The upper end of the social class would have been around. They would have been excited to have the Governor General here until they heard this. Now we must all admit that the condition of the Indian question in British Columbia is not satisfactory. 1876, Governor General Lord Dufferin. Not satisfactory. Most unfortunately, as I think, there has been an initial error ever since Sir James Douglas quitted office in the government of British Columbia, neglecting to recognize what is known as Indian title. The government of Canada recognizing this in 1876, that Indian title exists. In Canada, this has always been done. No government, whether provincial or central, has failed to acknowledge that the original title to the land existed in the Indian tribes. So Dufferin then continues to say, BC had always assumed that the fee simple as well as the sovereignty resided in the Queen. And so I think it's important to just to acknowledge that while British Columbia was on its own path, the government of Canada had a very different opinion of where Indian title was and where it existed. And it's not like something recent that they were acknowledging. It was 1876.
Thanks a lot, Adam. When I look at that and listen to that quote in particular, there's been quite a transformation, and there's still a long way to go, but in terms of the Constitution and the source and nature of legal rights held by First Nations, and almost every day I'm bumping into constituents says, what about Section 35? And there's a real interest and thirst to know more about how that is unfolding and how it unfolded after what Adam just described. So I don't know, Andrew, if you could offer some thoughts on that.
Hopefully I can. First of all, thanks, Rob, and thank you all for being here. It's a little intimidating for me because there's people in this audience that I've not only worked with, but people in this audience that I've learned from, and I know they won't hesitate to correct me when I get it wrong, as I no doubt will. It's also a little daunting to talk about the legal concepts that Rob's asked me to talk about, because as a law professor, I'm used to 50-minute lectures, and the topics are probably ones that would take up a full course over the course of a semester. So to make sure that I try to do it efficiently in a user-friendly way, I've made some notes to keep me on track and hopefully make it as accessible and understandable as possible. Starting with the concept of Aboriginal title. And what is Aboriginal title? Aboriginal title is really the full beneficial interest in lands that First Nations occupied continuously and exclusively prior to the British Crown claiming sovereignty over those lands, which in British Columbia's case was in 1848. It sits alongside other Aboriginal rights, such as the rights to hunt, to fish, to trade, or engage in other practices, or their modern equivalents that were integral to First Nations' distinctive culture at the time of European contact. And such rights continue to exist in BC because, as Adam has explained, they were never ceded to the Crown through treaties or other instruments, as was required by British colonial policy, dating back to the Royal Proclamation of 1763. So the British Crown said that First Nations rights could only be extinguished if they were ceded to the Crown, and only then through treaties or some other formal process. And as you've heard, that didn't take place in BC because some of the actors in BC went rogue and decided to ignore that requirement, which is why we're in the situation that we're in today. Now, after Confederation, when provinces were given certain powers under Section 92 of the Constitution Act and the federal government was given certain powers under Section 91, The provincial powers did not provide the powers with the power to extinguish Aboriginal rights. So the province did not have the capacity to extinguish Aboriginal rights when it came into Confederation. And if you're wondering why it is that the governments of Canada and BC didn't raise extinguishment in their arguments, as we often hear in the media, it's because the courts have been very clear the province did not have the power to extinguish rights under the powers that were granted in the Constitution when it joined Confederation. As a result, such rights continue to be protected by the common law, and in 1982, when the Charter of Rights and other constitutional reforms were brought in, Section 35 of the Constitution Act, not part of the Charter, separate from the Charter, gave constitutional status to those rights. So what had been common law rights effectively became constitutional rights, including Aboriginal title, including the other Aboriginal rights that I've referred to, such as rights to fish and hunt and engage in other practices and their modern equivalents. The fact of constitutionalization of those rights breathed new life into them, further protecting them from government encroachment, and also, interestingly, protecting them from encroachment by the Canadian Charter of Rights and Freedoms. A specific provision, Section 25, was put into the Charter to make sure that, say, equality rights couldn't be used to undermine the commitment to Indigenous rights. And one important result of Section 35, and I mention this because it's going to come up in one of the cases we're going to talk about, was the subsequent development of a duty to consult and accommodate First Nations where their rights are unresolved or may be at risk, as was held in the case in the BC Supreme Court decision in Gitxaala, which is one of the cases we're going to decide. So where there's a doubt as to whether Indigenous people might have rights, rather than prejudice those rights or the possibility those rights will be proved, the court said there's a duty on the part of government to consult with First Nations in order to ensure that those rights are taken into account before government takes action. So the duty to consult has been an important duty that has been imposed upon governments following Section 35. Now, Rob also asked me to talk a little about fee simple, because of course we're going to talk a bit about the intersection between Aboriginal title and fee simple. Fee simple is the means that the province used to grant private parties title over what previously had been Crown lands. And we know about 95% of the land in BC is Crown land. About 5% is privately held, and all but about 1% of that was, of the Crown land, all but 1% is provincial, the rest is federal or municipal. But 5% was deeded as fee simple land to private parties, either individuals or corporations. Contrary to popular belief, fee simple does not grant one full ownership of land. It grants one full ownership of an interest in land, and that's an important distinction, because the Crown continues to hold the underlying title over all land in British Columbia. And that is true of both respect to fee simple and also with respect to Aboriginal title. In fact, the courts, I'm not sure if First Nations people like this description of it, but the courts describe Aboriginal title as placing a burden on Crown title, recognizing that the underlying title still resides with the Crown, as it does in the case of fee simple. Thus, with respect to both lands held in fee simple and land subject to Aboriginal title, the Crown retains that underlying title. And that may become significant. In my view, it may become significant in how we resolve some of the contradictions that appear to emerge out of the Cowichan case, for example. One issue this raises, dating back to the 1997 Delgamutte decision, which confirmed that Aboriginal title cannot be extinguished by provinces, is what happens when privately held fee simple title and unextinguished Aboriginal title coexist over the same land. And that was the very question that was begged but not answered in the Cowichan case, where the court focused its remedies on publicly held lands and did not invalidate any privately held fee simple interests. And I know we're going to get to the case, but the number of people I've talked to who seem to think the Cowichan case in some way invalidated private land holdings is quite extraordinary to me, because the court did not do so. The court withheld a ruling with respect to the implications of Aboriginal title on privately held land. The only title they invalidated was Crown land held by the federal Crown or by the municipality of Richmond. So hopefully that gives you a bit of an overview, as succinctly as I can make it. I spared you an entire term of lectures, 50 minutes long, and sets the stage for further discussion.
Thanks very much, Andrew. And I realize this is starting to sound like a lecture, but we're really trying to lay some groundwork for the discussion later on and make sure we have a common understanding. What I'd like to do is just take a bit of time to talk about the cases that have occurred up to the day before the Cowichan decision, and some of the main changes in the law following on Section 35 of the Constitution, and how the court has wrestled with this up to the point of the Cowichan decision. And then I think we're ready to dive into the Cowichan decision. And so I'm going to ask Geoff to sort of speak to some of the key cases, and just so you have that background, and then we'll get right into it, and we'll have an opportunity for a few questions of any of the panelists. None for the moderator, but for the panelists.
Why are you doing this, Rob? Oh, sorry.
Before we get into the Cowichan case, because I just want to see if there's any questions around the sort of groundwork we're laying. But
Sure. Well, thank you very much, Rob. Thanks for inviting me to this. Thanks to all of you for coming. Let me say a few things. So Andrew and Adam, to some extent, have talked about how the initial ideas of Aboriginal rights and title actually are developed and were developed by judges in court decisions. Aboriginal title, Aboriginal rights are a branch of our law that is essentially judicially made. They don't derive from legislative acts. There's no statute that creates Aboriginal title. The courts have been at the center of the development of this law for, at least in modern terms, since the Calder case, which came from British Columbia in 1974, and is really always thought of as the first modern case recognizing the continued existence of Aboriginal title. Indian title was the phrase they used then, in the law of Canada. And in the intervening years, since the early 1970s, a series of court cases have essentially added flesh to those bones and have developed the ideas of rights and title more fully and extensively. And then, as Andrew pointed out, in 1982, with the enactment of Section 35 of the Constitution, the 1982 Constitution Act, the language in Section 35 is that existing Aboriginal rights are, quote, recognized and affirmed. So that language, recognized and affirmed, then causes the courts, starting in particular in a case involving fishing rights called Sparrow, which came from British Columbia in 1990, to say that the constitutional recognition and affirmation of Aboriginal rights changes their character from being sort of ordinary rights to being constitutionally protected. And that has at least two very significant consequences. The first of which is that it's the courts who decide on the detailed meaning of our Constitution. And when judges and courts make decisions about the content of the Constitution and what it means, it's beyond the reach of politicians or legislatures to change that. We live, as I have said on other occasions, when it comes to the world of Aboriginal title, Indigenous rights, we live in a judge-made world. And in large measure, that's because of the fact that we are talking about constitutional rights. And that's the first main consequence, if you will, of the constitutionalization of these rights. The second main consequence is that, and this is made clear in the Sparrow case, and then in some cases later that deal with land title rights, not only did the governments of Canada the government of British Columbia never had the constitutional power to extinguish Aboriginal title. After 1982, the government of Canada never had the constitutional ability to extinguish Aboriginal rights or title. But more than that, the government's ability even to regulate in a way that impacts these rights is very constrained. The courts in a case in Sparrow and then in Delgamuukw established a framework that says that government can only infringe, which is not the same as extinguish, government can only infringe Aboriginal rights and title if it satisfies a two-part requirement. The first requirement is it has to engage with the First Nations in a respectful, honorable way about the potential for infringement. And then secondly, it has to meet a very high bar, which I think the exact phrase in Delgamuukw is compelling and substantial. And so the court has to be satisfied that government, which says it needs to do this thing, really can persuade the court that it's absolutely compelling and substantial. Regrettably, we have almost no examples of the court accepting any government argument that anything was compelling and substantial. But I say that mainly to indicate that it's a very high bar. So the larger question at play, which is more a question when we get to DRIPA, is, so what is it that government can do in engagement with First Nations to try to ensure that the province is being developed for the benefit of everyone? The judicial narrative that started in Calder continues to this day. There are a couple of other really important cases. One is a case called Chilcotin, which was decided by the Supreme Court of Canada in 2014. Until then, the lawyer in me would say, we knew a lot about the idea of Aboriginal title. We knew that in theory, it meant that there was the ability to have the full beneficial use of the land for Indigenous people. But the courts had actually backed away from ever declaring Aboriginal title on an actual parcel place. In the Chilcotin case, the Supreme Court of Canada made a declaration of Aboriginal title to 1,700 square kilometers of the South Chilcotin, marking the first time in Canadian history when an appellate court had found Aboriginal title, and they found it in the heart of British Columbia. And since then, there have been two more cases finding Aboriginal title. One, very recently, a Court of Appeal decision in the northwest of Vancouver Island, on Nootka Island, and the other is, of course, the small area on the south of Lulu Island and the Fraser River, which is the center of the Cowichan tribes, is where the Cowichan tribes case takes place. There is one other case that I just, while I have the microphone, and you know, I'm so compromised. I'm a former politician, I'm a lawyer. Man, getting me to stop talking is just a bugger, eh? There's this other case that Andrew. I'm going to just do this quickly because we're going to come back to this. Andrew made this point about another important case called Haida Nation, where it's one thing to say, so here is Aboriginal title, here are Aboriginal rights, here are the limits on the Crown's ability to interfere with those rights. What about all the rest of British Columbia, where rights and title are asserted but have not yet been proven? Surely the government gets to just carry on business, waiting until the day when title is established or a treaty is negotiated. In 2005, in two Supreme Court of Canada decisions, the Supreme Court of Canada described that conception of the province's obligation as impoverished. That was the word used. And they held that in any case where the Crown has notice, real or constructive, of a asserted Aboriginal right or title, and contemplates conduct that might adversely affect that right or title, the Crown has an obligation to consult. And the intensity of consultation is a function of the potential intensity of impact and the potential strength of the claim, but it's on a spectrum. But what it means, and I say this in part because while it's really important we talk about Aboriginal title cases where title has been found, like Cowichan, what I don't think is all as well understood is that, from my perspective, the most profoundly transformative judicial decision in the history of British Columbia was actually Haida Nation, because it forever changed how the province can manage, develop, make decisions with respect to the resources of the province. From that moment on, Indigenous people are a part of the conversation about how resources and lands are to be developed. And there's a quote from this case that I want to say, read, because it's not often referred to, and I won't read the whole paragraph. But this is when the court is trying to figure out why, try to justify the development of this duty. The honor of the Crown requires that Aboriginal rights be determined, recognized, and respected. My point is that the question of whether we choose to do anything about Aboriginal rights is actually not a question. It's since that sentence, since the development of all this law, that's not an option. Our governments are constitutionally obliged to determine, recognize, and respect Aboriginal rights and title. So the question is not if, but how to do that.
Great. Okay, thanks very much, Geoff. Over to you, Adam.
I think I just want to just acknowledge that the King George, I think it was the third, right, in 1763, acknowledged what existed, right? Acknowledged that Aboriginal rights exist, and set in motion for the Crown, and as Geoff described it, that the judges have been making decisions and determinations, but this has been starting to being manifested within the British legal system. But the Crown was the one back in 1763 that made the original acknowledgement, and the ignoring it or setting it aside all of the years up until these decisions, judges have been making this law, as had been pointed out. I just want to point out that the Crown was acknowledging it way back, and it's been evolving and developing for us through their jurisprudence, and through the British common law. Do I have the right language here? That everybody in here relies on for the rule of law in our society. So Indigenous people are turning to and using that British common law system, right? Not our own Indigenous legal orders, right? So we rely on that legal system for the rest of the structure of our society. So it becomes impossible then to start to pull down the parts about it that make us uncomfortable about Indigenous rights, without also pulling down the rest of it that everybody relies on.
Yeah. No.
I'll just say, and it's British Columbia's denial of this that is the reason for 70 years of court cases of Indigenous people struggling to figure out how to get courts to recognize and give effect to this.
I just say that it's always struck me as a bit of an irony that Aboriginal title, which a lot of people assume is an Indigenous concept, is in fact an artifact of the common law, of the European common law, based upon an understanding of the commitments that were made in the Royal Proclamation, based on the fact that in British Columbia, the land that enjoyed these rights was not ceded because there was no treaty process undertaken. Well, there was a few treaty process undertaken very selectively, but no major treaty making was undertaken. So those who think that this is an issue of non-Indigenous versus Indigenous people, it isn't. It's an issue of non-Indigenous and Indigenous people trying to respect the law, which happens to be a law that comes from the British system.
Nicely put. And so we're at that point where we're going to shift gears momentarily. Is it fair to say that up until the Cowichan decision, that title claims had not involved private fee simple lands?
Yeah, correct.
I think that's right. Maybe you could comment.
Well, so in simple terms, the two leading Aboriginal title cases before we get to Cowichan would be Delgamuukw, which we've mentioned several times, and the Chilcotin case, which we've mentioned. There are many others that I could cite for this, but what's important is that in both those cases, and this is also true in Gitxaala, the most recent Court of Appeal case, the First Nation claiming title expressly said we are not claiming title or in respect of private property rights. If I were characterizing that, technically I would describe it as a gratuitous concession, not an admission that there was no title, but simply we're not having that fight in this case. Our claim is with respect to all the land that is Crown land. So it's really not until the Cowichan Tribe's decision that you have the first ever direct engagement between an Aboriginal title claim and privately owned land.
Yeah, I think it's First Nations, even through the Cowichan decision, have consistently said that they are not seeking to displace fee simple title. But I would argue if you go back to the law in the Delgamuukw decision back in 1997, it's clear that Aboriginal title must apply to fee simple land, because fee simple was a title created by the province through its legislation and through its laws, and the court made it clear that those laws could not extinguish Aboriginal title. And so even starting in Delgamuukw, government should have started to think, and maybe courts too, and lawyers, if and when it comes to a head in a case that there is a claim of Aboriginal title in respect of fee simple land, how is that going to be reconciled? Because the two, I think one can powerfully argue, even in Delgamuukw, it's clear the two can and do coexist. Now, what that coexistence means and the implications of it are, of course, what is left unresolved by the Cowichan decision, but the Cowichan decision has really put a light on that issue. But I think if you go back to Delgamuukw, Cowichan is just a corollary, just an application of the logic of the Delgamuukw case. Fee simple grants were made, those grants did not extinguish Aboriginal title, therefore the land that was granted in fee simple is still subject to Aboriginal title, where an Aboriginal title claim is made out, not easily done, but where an Aboriginal title claim can be made out.
And I'll just say, if you're feeling frustrated or angry about First Nations and First Nations people having rights, then I would say that you've been, or we have been convinced that Indigenous people and Indigenous rights are in between you and the Crown. And I would suggest that actually the conversation with First Nations, and we hear this after the court cases, and as a negotiator, I know this, and from the other negotiators that I talk to, the primary relationship that we would like justice from and like to sort out is the one with the Crown. And that has been pretty clear by everybody that's been engaged, is that, and the Crown has been doing a tremendous job of putting the public in the middle, or putting First Nations in the middle, between them and the public and their constituents. And so it's a very frustrating place to be, and we can see it, multiple sides of the political spectrum now have once again, First Nations find themselves in the middle of these political debates.
I'm going to shift gears momentarily. I just wanted everyone in the room, we've got your names on an Excel spreadsheet, that there is going to be a quiz after this section of the afternoon. And so this is an opportunity, if you're not clear on everything we've talked about for the last 45 minutes, to ask a couple of questions, and then we'll shift to Cowichan. So I know we've got a microphone somewhere, I'm just wondering if we can, I think the gentleman here had a question, so if we can take him the mic, that'd be fabulous. And I just, I mean this for all questions this afternoon, if you can try and keep them brief, that would be helpful, and if you wish to identify yourself, that's great, but just please.
Okay, I'm not a lawyer, so I'll get right to the point. I think there's a lot of debate and discussion about the fine issues, but what about the time we have to solve this issue? And there are, conflicting claims on lands from different First Nations, and when is that going to be resolved so that we can start making determinations and come to a conclusion and then respect the decision that was made by those First Nations about how they're going to share that land or the access to the resources there.
Sure. Okay. I'm just going to ask John to pick up the mic after the question. John, start.
Sure. So I would say that in the overlapping, I want to be careful here. The overlapping claims, the shared territory issue, I think the genesis of that started when we were divided into Indian bands, frankly, and Indian agents and government agents put First Nations wherever, basically. And as many of our villages suffered from pandemics and from smallpox, First Nations were consolidated into places, and villages were moved, and there's a long history of that. And so there are people from geographic areas, put into the same reserves. That's one piece of it. Then the BC treaty process, you had to put your statement of intent. And so that is also based on this Western legal framework and theory that for negotiation, that you start with the absolute largest territory that you can imagine. You put that on your map, knowing that this process of negotiation gets whittled down to a smaller and smaller territory to see what you see with the treaties as they are now. A couple of pieces of crown land that can be turned over, that the governments feel can be turned over. And so item 1.1 of the Declaration Act Action Plan, which came out in 2019, was to deal with the overlapping and shared territory issues. And that process has languished, and it's been very, very slow. And it's been part of the implementation challenges of the Declaration Act, was to put in place a process that can start to unwind what has been wound up in a very confusing and complex way, and that frankly has made for very, very challenging relationships between First Nations. When you take a look at the Saanich Peninsula here, our elders will tell us we are one nation, Saanich Nation. And yet we've been split into 5 villages, and each of those are becoming their own kind of nationhood, evolving that way in a way that doesn't make any sense to the elders that tell us that we are one people, a collection of families speaking the same language. So again, there has been no small impact of the policy decisions that were made for Indigenous people, on and to Indigenous people, that now we have to unwind, and that become very complex, and also an excuse as to why it's going to be very challenging for us to do this work, almost to the point where there's paralysis. We can't imagine a way to solve this problem. And yet, I think First Nations leaders have been saying we can imagine many of them, they just haven't been taken up by the province.
Yeah.
Well, just to deal with another aspect of the question, which is a great question. The short version of this is that the pathway to achieving some measure of resolution of these issues is negotiation, in my view, not litigation. And negotiation can take the form of treaties under the modern treaty process established in the early to mid 1990s, which has proven successful in a few places, has also proven very challenging in lots of other places. But from my perspective, there's a host of other potential kinds of agreements that can be entered into that can achieve a measure of certainty that is the desired outcome in respect of particular issues. There are lots of businesses in British Columbia that have been doing this, especially in the resource sector. And one of the challenges around trying to get a read on where we are as a province at any given moment is, what do we choose to pay attention to? Do we look at, a major agreement in northern British Columbia with the Tahltan that is leading to the development of a major mine called SK Creek? Or do we look at the urchins that undoubtedly exist and do exist in other places? And I think the effort that has to be undertaken with renewed zeal is to look for frameworks and opportunities to advance negotiation. And that is a little advanced hint on my view about the Declaration Act, which we'll get to in a minute.
Last word to Andrew, and then I'm going to shift gears.
Well, I think there are different aspects to the issue, some of which may be clarified more quickly than others. I mean, we've been living with the uncertainty around the issue about Aboriginal title and fee simple since the Delgamuukw decision, but we live with it because it never surfaced. It didn't become part of the public conversation. The Cowichan case surfaced it, and some people, regrettably, I think, have taken advantage of that to try to raise serious concerns that they allege it creates for fee simple. I don't believe it does, but I do believe that issue can be resolved by the courts and will be resolved by the courts in a way that respects fully both fee simple title and Aboriginal title. And that can be done, hopefully, through the appeal that's being launched, although there's no guarantee the appeal court will actually deal with that issue. I would have preferred it through a reference. That can be resolved in a much shorter compass of time. These other issues, the broader issues of dealing with how we respect Indigenous rights, be it through treaties, be it through other measures, be it through DRIPA, is, I think, a long-term process. And First Nations have waited 150 years since Confederation for us to start to deal with it seriously, and it's going to take more time. But I think in respect to the issue in fee simple, that can be addressed much more quickly and will be addressed much more quickly.
Rob, there's a question back here. Can you take it?
Yeah, we'll take one quick question, then we're going to shift gears.
Yeah, thank you. Kier Portraits. I'm Métis Chinese, originally from Saskatchewan. I wear many hats in the region, if you know me. I have a main question, and it's really about having Indigenous people, and I think in this particular case, First Nations people stuck in the middle. I think that's probably a great way. I think that's a great way to be able to, I think, explain that relation of what's happening. And I wanted to know, or maybe just share, the question is, who is paying the bill for First Nations to be involved in this process? So that's lawyers, that's PR, that's politicians. And in your opinion, how should that be done in a better way, if there is a better way? Because I know through my work, I have an idea of who's paying that bill, but there's a lot of misunderstanding in that space, and I think a lot of the backlash is getting pushed onto First Nations and a lot of the responsibility. So just if you can make some clarity on that, or share your opinion on how that should be done.
Sure, yeah, if we can do this really briefly, and then we'll get into Cowichan.
Well, I imagine that it's being done a variety of different ways, being paid for a variety of different ways. And in some cases, it's First Nations who have decided to start the process as a negotiation and realize that there's leverage needed in order to make those negotiations work, because the province takes the position that they can't work on all the files at the same time. So they prioritize, and they prioritize the ones that have the biggest threat to their priority. And so First Nations then get moved into this position where the negotiation table needs to have a litigation file behind it. And so they start to invest resources to have that as a backstop and have that as leverage. It largely will come from either settlements, or it'll come from other programs that they are, basically there's not a lot of money, and there's not a lot of money in the negotiation tables. And so, I think that we can talk a little bit about how First Nations are funded overall to create more sustainable governance, and I think that's part of the solution going forward. But currently, right now, there's not a lot of funding to litigate and it becomes a decision that communities have to make if they don't feel like their negotiation tables are moving with any expediency.
I'm just going to hold that topic there, and we'll shift. We could spend a couple of hours on the future of treaty process, treaty negotiations, solving border determination issues, funding for the process, and so on. So I really appreciate the question, and we can pick this up at 4. One thing I wanted to just mention. I think we're all offering quotes that have been a bit of a guide for us, or something fairly revealing. And I remember in 1997 when we were reviewing the Delgamuukw decision, and I can remember sitting at the Paula Inn in downtown Victoria, equipped with great big binders as a young lawyer meeting with a nation. I had a binder for every councillor, and we spent about 2 days on Delgamuukw. But the quote that struck me as a pretty clear picture, at least from the Chief Justice at that time, was the last thing Chief Justice Lemaire said in his portion of the judgment. And he said, as was said in Sparrow, Section 35 provides a solid constitutional basis upon which subsequent negotiations can take place. Those negotiations should also include other Aboriginal nations which have a stake in the territory claimed. Moreover, the Crown is under a moral, if not a legal, duty to enter into and conduct those negotiations in good faith. And then this was certainly guided the work that I did as a lawyer over 25 years working with First Nations. Ultimately, it is through negotiated settlements with good faith and give and take on all sides, reinforced by the judgments of this court, that we will achieve what I stated in UNDRIP to be the basic purpose of Section 35, the reconciliation of the pre-existence of Aboriginal societies with the sovereignty of the Crown. Then his final statement, let us face it, we're all here to stay. And I think that infuses an important aspect of the work that we do. Is it's not about if, it's about how. And what we're seeing in these next 2 cases that we're going to talk about is the court weighing in a way to try and chart a path forward on some pretty critical issues. And we'll start with the Cowichan Court case. And I want to start because we often don't hear about the actual nature of the Cowichan's use of that property or that land. And so through the eyes, through an Indigenous lens, how is that area used, and what brought the Cowichan to the point where they said we're going to court, and I think, Adam, if you can describe a bit of the history of that, it would be a helpful start.
Yeah, well, certainly of no authority to speak on behalf of the Cowichan or how it is that they arrived at the court. I would say that these people of the Straits, the Saanich people, our Halkominum speaking relatives in Cowichan, Cowichan had a river. The Satanich fished almost exclusively through the southern Gulf Islands using a technology called the reef net. But we would often find ourselves on the other side of the strait at the to fish salmon, and this was one of those village locations where fishing was being undertaken, and as I understand it, or as it was described in the case, the James Douglas committed to making a reserve on that site, committed to Cowichan, and it never happened. And this was part of the challenge that we talked about Douglas's work, was that he made commitments and then failed to secure the surveys, which, there were stakes put in the ground, but the surveys came way after. And so this is a case of where the commitment was made that it was going to be a reserve, set aside for a reserve. And instead of doing that, Richard Moody, who was the Commissioner of Land and Works at the time, just hired an agent and sold it to himself. It was fraud, essentially. It was theft. And they knew all too well that it was supposed to turn into a reserve, but in this case, it ended up being part of Moody's land holdings. And so this is, the picture that's painted in the decision is one of a time in British Columbia where self-interest had really overtaken the key officials, and that they, as part of the gold rush, there was this land rush mentality, and this generation that came in after Douglas was really self-interested and really entrepreneurial in the way that they were there to do the business of the province, of this new province, but also to do the business to enrich themselves as well and make themselves wealthy. And that's an example of what we saw. And so the Cowichan, I think you go through the history, in the early 20th century, they're there asking for this to be dealt with all the way through. They're asking, all the way through the 20th century, they're asking for this to be dealt with. They get to the negotiation table, they're in the treaty process, asking for this to be dealt with, and then it ends up culminating into the longest trial in the history of Canada. And, and then we get this result in August, and the entire province melts down, over it. But really, this has been an evolving story for the Cowichan for that 170 years that you were talking about.
Great. And one thing I wanted to ask Geoff, and you'd probably be very familiar with this, is did the Cowichan not actually travel to see the King George or something to see if this could be resolved? They tried, back to Adam's point, they tried a whole range of ways other than going to court to try and see this resolved right from a long time ago, as I understand it. But I wondered, Geoff, if you could offer us a bit of a snapshot of the case and your thoughts.
Sure, the 863-page decision. So the Cowichan Tribes case is 4 or 5 First Nations whose winter villages, reserves, are on this side of the Salish Sea, come together, call themselves the descendants of the Cowichan Nation. They file a claim in the BC Supreme Court in 2014. They're asking the court to give them a declaration of a fishing right in the South Arm of the Fraser and a declaration of Aboriginal title over an area of about 1,800 acres on the south shore of Lulu Island that abuts the river, basically. The central contention is that this is a place called Tlakinas, and that it was, for time immemorial, was the place that the Cowichan came every summer to fish in the huge salmon runs down the Fraser, and they would catch all the fish and go back home for the winter. So there's a claim of Aboriginal fishing rights, and there's a claim of Aboriginal title. I won't give you the whole procedural history, but by the time we get to trial, there are 6 defendants. There's the government of Canada, there's the government of British Columbia, there's the Vancouver Fraser Port Corporation or Port Authority, because a lot of this land is under the management of the port, and there's the city of Richmond, who acquired land over the years through tax sales. This land has been industrialized for a century. There's been no Indigenous occupation of this land for at least a century. So there's lots of other people who have land interests in this area. The other 2 defendants are the Tsawwassen First Nation, my client, and the Musqueam Indian Band, both of whom argued against the claim. In fact, what's important for people to understand is that every aspect of the claim was contested at trial. Every argument was contested, not by every single defendant, but across the range of all the defendants. Every argument that could be made was made. And the narrative that you heard from Adam, for example, is significantly contested. It was significantly challenged at trial. The trial judge, though, made all the findings that Adam has summarized. And found in favor of the claim of fishing rights and the claim of Aboriginal title. Not on quite the whole area claimed, but I don't think that matters much for today's discussion. Every party has appealed. When we get to the Court of Appeal, I expect that all of those findings that were summarized eloquently by Adam are going to be challenged by one party or another. So the first thing to say about the Cowichan Tribe's trial decision is it's not the last word on anything that it has decided. It is, however, the law for the parties, and as law may be extrapolated from the decision more generally, until such time, if any, if ever, as the court overturns the trial decision. There are lots of interesting legal aspects of this case, but I want to focus on 2 as opposed to the 22 that occur to me. The first is to make the point that it was essential to the Cowichan claim that they made the argument that Adam summarized for you, which is to say this place was a special place. It was a village. It wasn't sort of just a big mountaintop or a large river valley or agricultural area that was used for hunting or trapping. It was a place that had been core to the identity of the Cowichan, was a village, and they argued and they persuaded the judge was the subject of a specific promise made by Governor Douglas. And to me, the reason for saying this here is for you to understand that this case is very fact specific, and not every situation is going to produce the same facts and the same outcome. And it's wise to be as attentive to that as you can be. The second thing is that from that finding of theft, the judge was clearly, I'm going to say motivated profoundly by this. And so she deals with the 3 different kinds of land in the claim area in different ways. There's land owned by Canada and or the port, land owned by the city. She says, the best way to deal with the situation, and I'll spare you the 2 pages of legal analysis about how it's an unjustified infringement and a breach of fiduciary duty, is all that land, which is in the hands of public governments, must be returned to the Cowichan. That leaves 1/3 of the land, which is all owned by private property owners, a golf course, a waste management facility, small farms. None of the individuals who owned that land were parties to the case. That's because the Cowichan never sought a remedy against them. But the Cowichan did seek a remedy. They asked the court to declare that the land, that all this privately owned land, was held in Aboriginal title, And I'll simplify things, they asked the court to make a declaration, which she made, that the Crown and the coalition have to negotiate with each other on what reconciliation will look like with respect to that land, which comes back to a point Adam made earlier about how the real contest is between Indigenous peoples and the Crown. Now, I have a slightly different perspective than Andrew on the implications of all of this. I do think that there are implications for private land ownership when you discover that a court has declared that the land that you own is also being held by a First Nation in Aboriginal title. And the judge makes a very clear point. He says, this is unsettled law. I have to do something about this. This is how I'm going to decide it. The logic he uses is pretty much the logic that Andrew told you about earlier. It derives from the Delgamuukw case. But I think that what we need to know is, while we are, in fact, at a moment of some uncertainty, it's not really, it's not everywhere. It's really, specially rooted in the unique history of this place. And there is an unresolved issue in the law over the long haul about how Aboriginal title and private land ownership will be resolved. But it will be resolved in a way that does not involve dispossession of the non-Aboriginal population of British Columbia. There was no dispossession of private land ownership in Cowichan, and there is even a question of whether her reasoning will survive in the Court of Appeal. But I don't want to leave the impression that that this case was not about private land, because it is in part about private land. But it's a very careful understanding of the limited way in which it deals with private land, and an understanding that, I'll say this last thing, I do work for First Nations. I've worked for every level of government. I've worked for corporations. I've worked for individuals. In this case, the Cowichan, and I presume to speak for them, although I have no right to do so. This was a very special place for them. And in order for them to reestablish their connection, the asserted connection to it, they had to make the claim they made. But the vast majority of British Columbia is a place of opportunity for Crown Indigenous relations to be fully realized without any implications for private land ownership.
All right, okay, thanks a lot. Adam? Sorry, Andrew?
Yeah, well, thank you, Geoff. I think it is really important, as Geoff's illustrated or commented, and Adam too, to understand the Cowichan case in light of its particular history and the injustices that the court clearly felt were there, and it motivated the court. Having said that, there is, as Geoff says, a holding within the case that Aboriginal title applies to land, some of which is private. And that has given rise to a conversation, I think sometimes an intemperate conversation, and allowed some people to claim that private land, fee simple land, is somehow at risk in respect of that case. And indeed, the government itself raised that specter and said it was one of the reasons it was going to appeal was to try to overcome that. I have a different view. I don't think private land is in any way at risk from that decision. And I say it because there's always a danger in looking at the law dissociated from social conditions or attitudes. I used to do it as a law professor. You take some case and you run it through to its logical conclusion, and you say, oh my God, this could lead to all sorts of horribles. But there's a school of law called legal realism. What legal realism tells you is to understand how the law is going to evolve, you really have to understand the social context and the attitudes and how judges are going to approach this. And I don't think there's a chance in the world that the judges ultimately who are going to decide this are going to hold that fee simple land and the system that establishes fee simple land is somehow undermined in some way by Aboriginal title. First Nations haven't asked for that, and I just don't think it's going to happen by any stretch of the imagination. So I asked myself, is there a way out of this looking at the legal doctrine? First of all, there's a whole bunch of writers who write about Aboriginal rights and Indigenous rights in support of them who've addressed this issue and who say, yes, Aboriginal title can apply to private land, but none of them suggest that the implication of that is somehow that fee simple title is going to be somehow undermined or dispossessed as a result of that. They have different responses as to how it should be addressed, but none of them suggest that it would be appropriate for fee simple title to somehow be threatened as a result of that coexistence. And then I look at the court decision itself, and I think the court decision itself has at least one strategy that could be used very effectively. Because in the case of Richmond, Richmond tried to argue that the land that it held that was subject to fee simple should not be returned to First Nations because of an equitable principle called a bona fide purchaser for good value. In other words, in equity law says, well, you've done something to purchase land or acquire land for good value, and you're an innocent party, you should be protected. And in the case of Richmond, the court seriously treated that argument. Appears the court might have applied, maybe even would have applied it, but they said in the case of Richmond, the land wasn't acquired as a purchase. It was acquired through a tax sale, and therefore it didn't apply to that particular land. But the strong implication is that an equitable principle would have been applied and could be applied to protect private land. That's not the only way. There's a New Brunswick court decision where the judge essentially says, this can't possibly result in undermining fee simple title, and comes to that conclusion and quotes Kent McNeil, who's been a leading proponent of Indigenous rights, but comes to the conclusion that fee simple title is not threatened. And I would point out, there's been a lot of hysteria raised, and we're going to talk about in relation to the United Nations Declaration on the Rights of Indigenous People and its application. If you look at Article 28 of that declaration, it contemplates this very situation. It says that where land is subject to Indigenous claims and restitution is not possible, fair and equitable compensation for the lands should be provided. I'm paraphrasing it. So what's the solution here? It seems to me quite obvious. Remember I said there was underlying Crown title. It seems to me the Aboriginal title continues to burden the underlying Crown title, and that places an obligation on the Crown to provide redress. That redress could be in providing alternative land, in providing alternative rights, in providing compensation. So Aboriginal title can continue to exist as a burden upon the underlying Crown title. At the same time, the fee simple title can be protected through some doctrine. The most obvious one, to me at least, seems to be the equitable doctrine around bona fide purchaser for good value, but it could be through some other equitable doctrine. Whatever it is, I just do not believe, when you look at the history of this country, the role of the courts in protecting private property, and how destabilizing it would be for the courts to hold that private property is somehow threatened, that there's a remotest chance in the world that a court is going to decide that Aboriginal title results in fee simple title being somehow undermined or dispossessed. It's just not going to happen.
Well, and all it takes for the Crown to have sovereignty and title is to assert it, and all it takes for Indigenous people's Crown or the title to be recognized is to fight like hell for 500 days in court. Right? Just a simple assertion, this is ours. Made it that way. The system then gets set up on top of it. And what we find in the province, and I think part of where I'll lean into what Andrew just said is the entire system, not just whatever assertion of private property rights or manifestation of private property rights that we may feel that we have, or you may feel that you have, is in question. It's like the whole system. I talked about how in the legislature, I talked about how Vancouver Island at one point was at one title. It was right after the Oregon Treaty, and the Crown said to the Hudson's Bay Company, settle this, make way for the settlement of this land. And since then, it was a subdivision and sailing. And as I'm not going to be partisan, but as a former Green politician, I talked about fracking the land. Right? In the same way that we frack the shale for gas and it releases a humongous amount of wealth every time we do it. Same thing happens every time a subdivision of land happens. You frack it, you create a smaller lot, huge amount of wealth is created. The system that relies on that in order to power our economy is going to defend it, and that's exactly what we see with our politicians that jump out and defend it. They're not defending your private property rights in as much as they're defending the system that they've established on top of the point that I made at the very beginning of this, which was they didn't do the work that the Crown said they needed to do in order to be able to set the system up legally. So they set it up illegally. And that's the real threat as I see it, and what our governments are their reactive responses to defend that system, because it's not just a single private property owner's rights that is in question, it's that whole system on top of it. And so why are we going to resolve it? Because we are all, as my grandmother said to me when I was sitting in her living room back in 2004, 2005, exactly the same as what Justice Lemaire said. We're all here. We're not going anywhere. It's incredibly toxic for us to be every 10 years fighting with one another like we are right now. That's toxic behavior. It needs to end, and we need to build relationships because we're not going anywhere. And we've got to figure it out, and we've got to get it together. And so, she sent me out into the world, and here I am. But it's not an individual's private property rights that this government is responding to or reacting. It's the system that was created on top of it that has been called into very serious question by our courts. And it does require a society-wide response to finding a way to solve it, and that's what I think we're going to get to at the Declaration Act, is governments trying to find a solution and a framework to be able to deal with this very serious question that was planted right at the heart and at the root of this province.
Thank you all. So I'm going to do a lightning round, and then I'll ask a couple of questions, and then we'll shift to the final topic. We're at about 3:30, so we're not too far off being more or less on time. So obviously this case is going to go through appeals, and as Geoff was saying, probably every single part of the decision is going to be appealed and under appeal. That's going to take a bunch of years until we actually find out where things land, assuming that it goes right to the Supreme Court of Canada. And so, and the Supreme Court of Canada will, if it gets that far, which I'm pretty sure it will ultimately clarify a range of issues. But to Adam's point, the work can be done now in terms of figuring out how to reconcile the fact that we're all here to stay with that particular decision, and to do it in a way that doesn't leave it to the courts. But in the meantime, we have a variety of folks who are saying, is my private property at risk as a result of the Cowichan decision? It's described in different ways. Is the Cowichan decision a threat to my property on Pender Island? Is it a threat to your property wherever you live? And so I'd just like to quickly hear from each panelist your assessment of that. Some of which we've covered, but if you can just do a 30 seconds each. Should I be worried?
No, I don't think people should be worried. Look, I can't do that in 30 seconds. If you, like me, live in a house in a neighborhood in a city, and some nice trees growing in the front of it, you're not at risk. What I would say is that if you're planning a $25 billion mining project in northeastern British Columbia, then you better sit and do some work about who the Indigenous people are in that territory and find out how you can engage with them to establish relations that might actually end up in a partnership that allows the project to go ahead. It's a long, complex, careful process. You should not go into that process thinking that there are no rights on the other side of that table. But there is nothing in Cowichan that is intended to unsettle what I'll call ordinary private property ownership in British Columbia.
Okay, that was only 45 seconds. That was good.
Well, I think I've already said why, from a number of different perspectives, I don't think that private property is at all at risk as a result of this decision. I don't think this decision really says much different at this stage than the Delgamuukw decision said. And I think the court will ultimately decide a way forward that will both respect Aboriginal title and respect fee simple, and that the two will in fact coexist, because I don't see that they need not coexist in a way that will achieve both those results in the way that I described earlier. I do have one niggling anxiety, maybe Geoff can reassure me, that this issue might not be decided through the appeal process. To the extent that the court did not decide the rights of private property owners here who were not represented, the appeal court might well say this is not an issue for them to have to address. And my preferred route would have been for the government to put what's called a reference, that is a question, directly on this matter to the Court of Appeal, which could have clarified it much more quickly and then had it go on to the Supreme Court of Canada more quickly. The trial process is going to be much more protracted. But Geoff, and you may think I'm wrong about this, but I think there's a risk, maybe the court, knowing how important it is, will overcome that risk, but there's a risk the court will say, well, this issue really isn't before us. Because in fact, the trial judge did not hear from private property owners and did not make a ruling with respect to the specific rights of private property owners in relation to Aboriginal title.
Sometimes I think we are. Don't you have the feeling sometimes we're sitting in a fourth-year law postgraduate seminar on the subtlety of references? Look, it's absolutely the case that you can't predict what the Court of Appeal will do. What I can tell you is that the issues that we're talking about are front and center in the case now. They will be front and center in the arguments made as the case moves forward. And what I have sometimes said in my life, and is true, judges read the newspapers just like we do. They know how important this issue is. I would be startled if the Court of Appeal did not find a way to provide some clarity on this point.
Legal realism cuts two ways.
Yeah, okay, over to Adam, do you want to?
No, they can keep debating with themselves, with each other. I'm learning something here. No, I don't think so. I think that, and that will be significantly helped when the Crown, the legislative and the executive branches actually reinvest in sitting down at the table and having productive conversations with First Nations and begin building relationships and building agreements. And begin providing the access to the wealth and prosperity that come from our territories.
Great, okay, thanks. I am going to exercise the prerogative of the chair because we've only got about 25 minutes left, and there is half an hour after the meeting ends, so you can relitigate the question of whether or not you should worry about your fee simple property. What we're hearing is be calm and carry on. What I would like to do is turn it back to Adam again and start in on DRIPA and UNDRIP, and then we'll talk about how the case, the Gitxaala case plays into that. But Adam, you were there in 2019 when DRIPA was unanimously adopted by the legislature. What does DRIPA mean, both symbolically, and I mean that in I don't mean that in a de minimis way, like it's an important symbol, and practically to First Nations in this province?
Well, first of all, I think it's important to acknowledge the decades of work that was done at an international level that had the full engagement of First Nations leaders from British Columbia and from Canada, with our relatives from places all around the world at the United Nations, a deliberative democratic process that brought us the United Nations Declaration on the Rights of Indigenous People. And I just want to acknowledge that was incredibly important work. Indigenous people in Canada have had an experience that unfortunately is not unique. It's an experience that Indigenous people have had around the world, and that's the reason why we have an international approach to this that brings us 46 articles that is the very base, the baseline as to how states should be recognizing, respecting, and embracing Indigenous people's rights. It shouldn't be a surprise, it shouldn't be a threat, it shouldn't be fearful, it's just the basic human rights of Indigenous people. And I think that it is based in recognition, and the Declaration on the Rights of Indigenous Peoples Act in 2019, the process that was started, it was a commitment that was made between the government, the NDP government, and the BC Green Caucus to work through and bring the Declaration of Act into law in the province. It's a point in my political career that I'm incredibly proud of. And for me, it signaled the provincial government that had been spending every waking moment trying to find a way to reject Indigenous rights and reject Indigenous title, resist it, push it back, push it into the dark corners, and basically relegate Indigenous people into those dark corners, into the shadows of our province. It signified a turning point in this province's history. And that's why I think so practically it provides for us that recognition that then we can build our negotiating tables around. When the province recognizes it, we don't spend weeks and weeks and months and years on end arguing about whether or not those rights exist and that title exists. So it gets a lot of that work out of the way. Which brings me to when a government says that they're going to pause it or they're going to repeal it. Symbolically, that sends a message to First Nations that we have gone back to the darkness, gone back to the dark shadows, and Indigenous people are being pushed into those very uncomfortable spaces into our society. And so, when you have a premier or when you have politicians saying that they're going to repeal it or to pause it because it's creating some discomfort for them, symbolically for First Nations, it's sending a message that that perhaps we need to sharpen our litigation files and find public relations and all of the things that we would rather not be spending our resources on. We should be investing them into the negotiation tables. So it's an incredibly important tool for First Nations because it represents a moment in BC's history where we turned a corner, and we do not want as a society to be turning a corner back into that darkness.
Okay, thank you. And maybe what we can do now is, because the work was happening on DRIPA, I wasn't going fast enough. There's my personal view. There was a lot of work that we saw under DRIPA, and but it didn't dominate the news cycles and didn't dominate debate in the legislature and outside of the legislature in the way it does now. And I think that's because of one particular court decision. I'm wondering, Andrew, if you can give us a bit of a rundown on that and some of its implications.
Yeah, that's a Gitxaala case, and I'll try again to use some notes to discipline myself to keep it fairly brief. But I think, just to start with, I want to dispel what you might have heard, because it seems to be a misconception that's shared by some. DRIPA did not form the basis of the decision in the Cowichan case. And the case about DRIPA that I'm about to talk about did not engage private property rights. So the notion that somehow DRIPA is a threat to private property, which is being bandied about, is completely bogus. To the extent the issue of private property has been called into question, it's been done through Section 35 and the judge-made law that Geoff referred to. And the attempt to try to pin that on legislatures or on governments of whatever stripe is simply a political move. It is not one that's borne out by the case I'm about to talk about or about the Cowichan case. So what was this case about? Well, the Gitxaala case was a case about DRIPA, about the Declaration Act. And I think to understand it, you have to understand it was a Court of Appeal decision that really caused the controversy that we hear about. But to understand the Court of Appeal decision, it's helpful to talk about what the trial decision in the BC Supreme Court was about. This was an action brought with respect to the Mineral Tenure Act. Under the Mineral Tenure Act, it's an act that goes way back in time. It allows prospectors to state claims on land in pursuit of mineral rights. But it did not require that those prospectors or anyone on their behalf to engage in a consultation process. And as we've talked about, there is, as a result of Section 35 of the Constitution Act, a duty to consult where Indigenous rights may be threatened or imperiled. And so the Gitxaala brought a case relying on Section 35, but also relying on the Declaration Act, saying that the Mineral Tenure Act regime was in violation of the duty to consult under Section 35, and they also drew in an argument based upon the Declaration Act and said it violated the Declaration Act, and through the Declaration Act, the United Nations Declaration on the Rights of Indigenous People, UNDRIP, which the Declaration Act is all about bringing into British Columbia to bring about legislative reform. The Supreme Court, the trial court, held that there was in fact a failure on the part of the administration of the Mineral Tenure Act to respect the rights of Indigenous people because it didn't have a process of consultation, and it held that there had to be such a process of consultation and gave government 18 months to develop one. In fact, I believe that work had already been going on within government even before this case, understanding that it would not pass muster under Section 35 of the Constitution Act and the duty to consult. On the second argument that the First Nation brought, namely that there was also a violation here of DRIPA, and through DRIPA of UNDRIP, the trial court said no. The trial court said that DRIPA was not intended to be an instrument that could form the basis of legal actions. Lawyers use fancy terms like it's not justiciable. All that means is it was not intended to be used in court. It was intended to provide a process through which government would bring about legislative reform. And it was not for the court to undertake that reform. It was for government to do so. They also held that UNDRIP was not part of the law of British Columbia. The First Nation and the government, the government did not dispute the Section 35 holding. But the First Nation did dispute the holding on DRIPA. And they brought an appeal focused on the fact that they said that the court should have also based a ruling on DRIPA, not just upon Section 35. And in the Court of Appeal, 3 judges sat, and 2 of the 3 agreed with that position. They said that DRIPA did provide a basis under which a legal action could be brought, and through it they found that there was a failure on the part of government through the Mineral Tenure Act to engage in a duty to consult. And that failure was grounded in DRIPA and UNDRIP, not just in Section 35. The third judge went a different way, actually went a different way on 2 issues. The third judge disagreed with the trial court, said UNDRIP was in fact part of the positive law of British Columbia, but disagreed with the other 2 judges, saying that DRIPA was never intended to provide a basis for legal action. In fact, he went further. He said that, in fact, it would be inappropriate for the courts to step in and start engaging in a process of legislative reform, which was intended to be a process that was given under DRIPA to the legislatures. So the question then arose, well, what does this mean? What does it mean that we now have a BC Court of Appeal that says that DRIPA can provide the basis of legal actions apart from Section 35, and it can draw in the principles of the UN Declaration of the Rights of Indigenous People? And this is where others, Geoff and others, may well have a clearer understanding than me. But it seems to me the implications of the decision are somewhat unclear. The BC Court of Appeal did not appear to treat DRIPA as a self-executing code or independent body of law. They seem to invoke it in support of the Section 35 holding. And I don't think their holding went much beyond the Section 35 holding. In other words, they'd already found in the BC trial court that government had to change the law to provide a duty to consult. I think in practical terms, the Court of Appeal decision didn't change much. But it created concerns on the part of government that somehow it would give rise to further legal actions using DRIPA and UNDRIP as the basis for further legal actions, and prompted the government to respond in the way that we've all heard about, namely to say not only that they would appeal that decision, but initially that they would make amendments. Now, I have certain views on whether that was the right thing to do that I can share, but hopefully that at least gives you the context with which we're dealing and explains how the two cases, how the two courts interacted. You ended up with two judges saying not justiciable, two judges saying it was justiciable, but since the two who said it was justiciable could be used in court were in the Court of Appeal, that is the current law, subject to appeal.
I guess
Very clear.
just before we go to Adam, I want to highlight that as we go into the law, and it's important to hear the case, and as Andrew so clearly and articulately set out, you know, the complexities of this case and the split decision, is that this is another case that'll be, you know, appealed, and we'll see what happens, and so it'll be a bunch of years. Meantime, the impact of the case so far has been through a variety of decisions and actions and communications, has been to set back the work that should be happening under DRIPA, and setting in place a whole process that I'm hoping Adam will touch on in terms of his perspective and his observations. But the point I want to make is that we didn't need to have this type of controversy, which is even slowing things down further than they'd otherwise be. And I don't think you'd find many First Nations that aren't saying this ought to be properly resourced, and the work under DRIPA ought to be much more serious. One question I want to come back to, and then I'll stop using Adam's time, is one of the main arguments that we seem to hear is litigation risk, and that this decision creates a huge amount of unmanageable litigation risk. And I do want to come back to that, because I want to hear from both Andrew and Geoff their thoughts, but I didn't want to. Why don't we do that first, and then we'll come to Adam? Is the world ending as we know it?
Well, I think you've heard from Andrew on that point. Is there a litigation risk? Yes, the answer is. There are now a whole bunch of court cases underway in which people are using this argument that Andrew described to challenge government decisions. And there are, in fact, already some decisions in which the courts have applied this to give effect in the law to the Declaration Act. The example I like to use is that there is a decision of a Freedom of Information Commissioner holding that a First Nation should get a fee waiver for an FOI request. because there is a provision in the UN Declaration that the commissioner, the adjudicator, found supported the argument that a First Nation should get a fee waiver in these contexts, and the adjudicator relied on the Gitxaala decision and the Declaration Act to make that finding. My point, really, in using that as an example, is that while there are many people who will tell you this is what they thought the Declaration Act meant when it was enacted, and to be fair and honest, there are a variety of different perspectives about that. I don't think most people sitting around the table drafting the Declaration Act in 2019 thought that it was going to fundamentally alter how the Freedom of Information Protection of Privacy Act in British Columbia went. So I do think there is, there's a sense in which this BC Court of Appeal decision has had an impact which, from the government's perspective, is not the intention behind what the work that is supposed to be done under the Declaration Act, which Andrew and Adam have both described. I'm not sure what the right adjective is in front of litigation risk. Some litigation risk, litigation risk. It doesn't feel to me yet like it's a massive litigation risk. On the other hand, the government's point, for better or for worse, is that they didn't think there should be any litigation risk. And to be fair, and perhaps less subtle and nuanced than Andrew was, the judicial scorecard on that is that there are 2 judges who agree with that proposition. And so there's some force in the idea that the courts agree with the proposition that the Declaration Act was not going to be available or shouldn't be available as a tool to challenge the entire legislative framework of British Columbia. I do want to say one more thing about DRIPA and why it's such an important part of our legislation in British Columbia, in addition to all the other things that have been said. What DRIPA does, among other things, is it creates a legislative framework for the work I described earlier, and it has been talked about. How do you discharge that duty of consultation that arises all over the province in ways that are often uncertain because the extent and nature of the claim of rights and title is uncertain? What you want to do is to include, engage, negotiate with First Nations. What's the best way to do that? Is it just to keep a list of all their phone numbers, or is it to wait for problems to arise and then respond? Or is it to create a framework within that which that work can be advanced? And while Adam, I think, is better qualified than I to say whether the framework has been adequately exploited, the fact is that DRIPA creates that framework. It provides for action plans. It provides for agreements with First Nations. It's a sort of a lodestone against which government can say, this is, and we can say as citizens to government, this is the work that you have committed to do. You should be doing this work, and this work will give shape and color and certainty to the outcome of engagement between Indigenous and non-Indigenous rights. I wanted to make sure that got said before we go back to the ugly world of how much litigation risk there is.
Well, I don't disagree that there's some litigation risk. I think it's been exaggerated. I point out that courts have invoked international legal obligations, including UNDRIP in cases even without DRIPA, to help influence their decisions. But what I think is really unfortunate about this is I listen to First Nations leaders who agree that the purpose, and Adam, you want to comment on this, but the purpose of DRIPA was to provide an alternative to litigation, was to provide a path forward where government would work in collaboration with First Nations to ensure that rights were brought forward and dealt with without having to go to the courts and entail all that expense and uncertainty. And it seems to me that the government's response to say we're going to amend DRIPA to this case kind of was throwing out the baby with the bathwater in terms of respecting that understanding. And it seems to me that, and I don't know, Adam can again talk to this more authoritatively as Geoff said, but to the extent that DRIPA was not achieving what it had set out to achieve, that the process was not working as well. This was a real opportunity for government to say, look, it's unfortunate in our view that this case was decided the way it was, and we will appeal it. But we're going to sit down with First Nations to ensure that DRIPA is working more effectively and create mechanisms. And as part of that mechanisms, try to secure agreement, not changing DRIPA, but secure agreement outside of DRIPA that will take DRIPA away from the courts and not make it a justiciable instrument. I think there was a bargain to be had. I may be naive, I'm out of the action, but it seems to me that a lot of the frustration that fueled this case was frustration about the fact that DRIPA was not being taken as seriously and was not being pursued as assiduously as First Nations had been led to believe it would. And therefore, court action was sought because of that. And that a government response that had said, well, look, we hear you, and now we're going to redouble our efforts and make sure DRIPA does work more effectively in order to achieve our shared objective of avoiding court action, could have resulted in an agreement that would have been far more positive than the place we're in right now.
Had the first stop after the Gitxaala case came down been at a meeting with the chiefs or with the leaders of this province, the rights-holding leaders of this province, that would have been the correct approach. But the first stop was to the media, where the politicians lit their hair on fire about the threat that they were now facing, that they had determined in the car ride from wherever they were to wherever they needed to be for that press conference. It was literally a matter of hours. There was no conversation with First Nations leaders about what the opportunity was to deal with the Gitxaala decision. The decision was made that there was an openness to amending the Declaration Act. And of course, that gets everybody's guard up. That gets everybody anxious and concerned about what that could mean. It makes everybody on the First Nation side of this very defensive. As I was saying earlier on, symbolically, you are now taking this and going in a different direction from it. What does that mean? Like, is it just for this or is it for everything, right? So there's massive questions that are a problem. And it also takes the focus away from the fact that everybody knew the Mineral Tenure Act was way out was way out of line and needed to be updated for decades. Everybody, when I was elected, we were arguing we were asking the question of multiple ministers, when are you going to update the Mineral Tenure Act to make sure that it's constitutional, right? So, I think that it's really important to have that context in this discussion. This notion that the Premier is primarily the one that's been raising this about the massive litigation risk. There is a massive litigation risk. It already exists. The fact that a lot of the land claims and land issues have been unresolved, all of those could potentially become part of a litigation risk that this province has been trying to manage or is managing at some point. So there's this perspective that's put out there and just in public relations that if we repeal DRIPA or if we get rid of DRIPA, then all of a sudden the litigation risk goes away. And I would say actually the litigation risk dramatically increases when you remove the tool that's supposed to be there to help you have effective tables. The Crown continues to point to Section 7 agreement that they've made with the Tahltan for the SK Creek mine, as was mentioned earlier on. I then asked, what are the other Section 7 agreements that you can point to? Section 7 is a section within the Declaration Act that's supposed to help First Nations and the Crown make shared decision-making and co-governance over areas. And the Crown can't point to this long list of Section 7 agreements. We asked for a Section 7 agreement for an issue that is currently ongoing in our territory right here in this, and there is no mandate for a Section 7 agreement. So the challenge is that when you have the Declaration Act, and it's providing a framework for us to negotiate agreements and to build these relationships legally going forward, and it's not being implemented, what tools do you have then to be able to ensure that the government that has that tool is accountable to it? Well, as Geoff pointed out, the law has been evolving by the courts and by the judges. And so you bring those questions to the places that can ultimately hold the legislative and executive branches to account. And it's the court. And so to have those questions be asked and for them to be clarified, we have 2 judges that are saying yes and 2 judges that are saying no. And as the system works, there will be clarity at some point as to how this works out. And it would be very helpful if all of the politicians involved just calmed down, just slowed down, just stopped trying to create a political advantage leveraged off of these deeply complex, very long-standing Crown Indigenous Crown, depending on which side of the ditch you live on or sit on, relationships that exist in this province, and that we're never going to be able to escape. We're only going to be able to find better ways forward.
And that's a wrap. It's 4:00. I just want to close by thanking my constituency office staff and everybody, and John Juricic and others that helped out to make this all happen and happen so well. And I also, want to take a moment to really thank the 3 panelists for sharing their wisdom and expertise this afternoon, and offer, and maybe we could just give them another round of applause. I know you're raising your hand. The session is not over. We've got half an hour where you can talk to the panelists directly, and I know that Andrew needs to leave momentarily, so I'm gonna say thank you so much. And I know we have one question, so I'll certainly allow that question, but then I just want to go one-on-one. So you've got the one question, but we need a microphone.
Oh, I don't know, I think I can...
No, I would like a microphone so it's recorded.
All right, thank you very much. My name is Jake. I just wanted to say, in respect to that, this all happens in a social context that was brought up, I think, by Andrew. Thank you for that, everyone. But that we have the ability to go to our MLA office and as a constituents and say, this is important to me, and this is important too. So let's actually do a call to action here and say, how can we take some of this information, go to our MLA in a very respectful way and say, we do want the constitutional rights to be followed. We do want this, and we don't want it to go through courts, because it's not a it shouldn't be a media thing, like Adam said. Indigenous people should not be put in the middle or made to be an obstacle. They are not. This is all us negotiating, and we need to use our rights go to our MLA in a respectful way and say, look at this. This is important to me.
Great.
So
Thanks very much. I'm gonna go to questions, individual questions now, because I promised I would do this all in 2 hours. So I apologize, Tom, you have to come up and buttonhole us. Okay, thank you so much. Have a great day. That was great. Thank you.
Thank you. And speakers, thank you so much for doing this. My name is John Juricic. I am the owner of a company called Harbor Digital Media, and we specialize in digital marketing and communications, specifically video production and promotion. I bet most of you, except for a few that I recognize, are saying, what is the Sydney Breakfast Club? Back mid-90s, numerous employees and engineers from the Institute of Ocean Sciences, that way, on Pat Bay, that way, thank you, were offered federal incentives to commercialize their products. And they formed companies, numerous of which still exist to this day. And these companies actually formed the basis of the technology sector and success in Victoria, was here. Peninsula, North Saanich, etc. So these engineers, etc., began to build their products and build businesses, and turns out some of them didn't know how to run a business. They were great engineers. So they started to have breakfasts together at the old Sydney Hotel, top of Beacon there. And that became known as the Sydney Breakfast Club. That has continued to this day. And I manage that business, or that organization. About 14, 15 months ago, a certain president was inaugurated, and immediate chaos entered into our lives. And that chaos has continued to this day amongst businesses that come to this club, which now averages about 100 people per month. They are uncertain. They don't know what's going to happen next. And therefore, questions about the things that go on in our society have come to me asking for some kind of clarity and education. And this issue is one of those. And so it became evident and painfully obvious that we need to help educate, and we need to help hear the viewpoints and help provide some certainty to our community and our business. Thank you so much for coming out today.